Hi everybody, this is Jack Meligan from the Plaintiff's MSA and Lien Solution here with you again. And last week I recorded a video about this conditional payments notice, the first one that we've ever seen, that is demanding that the plaintiff, well, or the beneficiary in Medicare's terms, but it certainly was a plaintiff, the plaintiff needs to refund $52,000 in conditional payments. And the point in my video, there were several, but the big point was that Medicare says they've been billed for $200,000 worth of services, and they've identified $52,000 as being related to the injuries or conditions that this particular claimant or plaintiff settled in a case where they received, as the government identifies, $1,500,000. CMS says in this letter they did not receive a settlement statement from an attorney. Therefore, they don't know that there are any procurement costs involved here, and until they get a settlement statement, they can't issue a final demand with a reduction for procurement costs, okay? But the really important part of this was, out of the $52,000, I identified that just about $5,000 of that 52 was pre-settlement services. And then $47,000 happened after the settlement. And this is the first time that we've seen Medicare CMS come and ask for conditional payments to be refunded to the government on services that were incurred post-settlement. That was the big smoking gun in that video. And then I said some other things, and really the point of the video, and maybe I didn't do a very good job because I got a complaint from an attorney about my video, and I'm going to read his complaint. But the point of my video was to say, hey, we offer these services of handling and resolving Medicare conditional payments and all other liens. And that was really what my point was, is to push our services. So after I posted the video, I got a reply, and anybody can go look the reply up. It's underneath the video if you want to see it, but I'm going to read it to you. It's from David Ranson in Springfield, Missouri. I know David. I met him once at a conference. He came up and talked to me after I spoke. Nice guy, and I understand an excellent trial attorney. But here's what David wrote me 2 days ago. Jack, please stop unfairly fanning the flames of fear to hype your services. This is not an example of needing an LMSA. It is purely an example of a plaintiff's attorney failure to abide by the strict rules requiring a final demand letter at the time of settlement and repaying to Medicare the reduced conditional payments. It is that simple. This lawyer messed up. If they had handled this correctly, no LMSA is required, and your violating Medicare's rules of the road would be meaningless. Sorry, that's the truth. David Ranson. David, thank you again for sending this. I disagree that I'm fanning the flames of fear to hype my services, and I never said anywhere in my video that this was an example of a case needing an LMSA. But since you brought it up, there is actually an application that an LMSA may have helped in this case. So let's review it. If the attorney, and I'm assuming there is an attorney in this case, if the attorney for this poor individual had resolved the Medicare conditional payments timely, which means at the time of settlement, then they would have already paid back some portion of this almost $5,000 of pre-settlement conditional payments. But what about the $47,000 that has subsequently been incurred and has also showed up now as a conditional payment in this report that Medicare wants that back too? Well, here's what would potentially happen in that situation. If the plaintiff decided to not do anything about addressing future medical that Medicare would pay related to these injuries and conditions that were settled as part of their settlement, then the plaintiff's got some choices. One of them could be they're going to not do anything about future medical and let Medicare come after them for it. In which case, we now know that Medicare is sending out quarterly letters to beneficiaries and stating, here's all the things that we were billed for on your account, and you can see what we paid, and if we didn't pay, take a look in the notes at the bottom of the page and we'll tell you why we didn't pay. And we've got several of those letters in here. And it's interesting, Medicare is now saying to Medicare beneficiaries that they've identified as having settlements, hey, we're not paying this bill because the code for this bill, the injury code, is the same injury code that was reported to us as being part of the release in a settlement that you got. You need to pay this from whatever Medicare set-aside arrangement you've decided to use. That's the government's term. When you see MSA in the vernacular out here, most people think that means a Medicare set-aside account. But when you step aside to the government's side of the table, they define an MSA as a Medicare set-aside arrangement, and there are a multitude of options for Medicare set-aside arrangements. Yes, a Medicare set-aside account is one of them, but the government has said, hey, plaintiffs are allowed, if they want to consider an arrangement for Medicare bills being their own checkbook, which means they're going to pay for these bills at the time of service. Unfortunately, I think that's probably the worst way to tackle this problem, because as I've said before, it means that your client's liability for Medicare bills related to their settlement is uncapped. They're going to pay them out of their checkbook for the rest of their life. They never get to the end. They never get to a place where they've paid all they need to pay, and from that point forward, by law, Medicare has to cover all of this. The only way to get to that place is to identify through an allocation study how big the problem is, what is the total of the total future Medicare allowable expenses for the injuries and conditions that are being released in the settlement agreement. And then minimizing that, if you can't avoid Medicare, we've talked about that before, because that's our approach. Our passion is helping plaintiffs avoid Medicare and an MSA. That's where we start. And then, if they can't qualify to avoid this, we got 3 ways they can do it, but if they can't fit into any one of those 3 ways, and they want to voluntarily create a liability MSA account or arrangement with which to segregate some funds in their own separate checking account or a savings account or a coffee can, or maybe their arrangement is they're going to have these bills paid by private insurance. That's certainly viable. Medicare recognizes that. As long as Medicare is not billed, they don't care. The point is, there's a choice here. And if the plaintiff has decided, I don't have insurance, I don't have an extra coffee can, I don't want to set up my own account, I want to set up an account and have it professionally administered so I never have to worry about this, and I've got some company and administrators that are watching my back and making sure I stay completely clear of all the Medicare rules. That's their choice. And the benefit of doing that is that you've gotten professional advice on a recommended amount of money to set aside, and if you did it as a plaintiff, once it's exhausted, you're home. Medicare by law has to cover everything, including your injury or incident-related medical for the rest of your life. That's why plaintiffs voluntarily create some sort of Medicare set-aside arrangement. They want to cap their exposure for future Medicare bills. So, David, you're right. This lawyer, and I'm assuming there is a lawyer because it's $1.5 million settlement, and it's kind of hard to conceive that just happened without some capable trial lawyer somewhere acquiring and obtaining that result. But this lawyer, whoever they are, in this case, yes, they screwed up. And basically what it appears they did is just completely ignored these issues. That is the absolute worst approach, because ignorance is no defense under the law. All you attorneys know that. It's been pounded into you. It's been pounded into all the citizens in this country. Every time we go to court or we challenge a police officer in a traffic stop, I didn't know about that, law officer. What comes out of their mouth? Ignorance is no defense. And ignorance of the law, I'm making that up, but ignoring the law is also not a defense. It's not even a very good strategy, because this is what can happen. Your client can get a nasty gram from CMS or Medicare saying, hey, we want a check for $52,000. The problem with this is, if that's your strategy to ignore this, you are creating an incredible long tail liability across all of your cases and settlements in your office from now going back maybe as much as a decade, but at least to 2012, January 2012, when reporting requirements started. Why? Because Medicare has stepped up their game for enforcing their secondary payer rights. They're coming after plaintiffs and plaintiff attorneys. Now, David says I'm unfairly fanning the flames of fear to hype my services. No, all I've ever reported on, David, is the facts. We've reported on attorneys who have been punched in the nose by Medicare. We've reported on attorneys who have lost their law license, who have been suspended, who have voluntarily forfeited their law license for not dealing with these issues. We have reported on attorneys who are in litigation with Medicare Advantage organizations and are subject to double damages for not having addressed the Medicare conditional payments that the Medicare Advantage plan paid. That's all I've reported, just the facts. And here's my answer to the whole fear charge. If you listen to my video or videos, read my material, talk to me. No, I'm not trying to press the fear button. I'm just trying to say, if you're ignoring this, you are playing with fire. The government has ramped it up. We know that because of this letter and others like it. We know it because we've got letters from Medicare that are going to Medicare beneficiaries that are quarterly statements identifying everything that Medicare has been billed and what Medicare has paid and the reason that they may not have paid. And when you go to the bottom of those sheets where Medicare says, we didn't pay this, see the notes below, what you're going to find in many of these cases of yours, and you may see this, you may have a client that brings this to your attention if you've been ignoring this, because they're going to say, hey, I thought you told me I didn't have to deal with this. I thought you told me that there was no legal law requiring me to do anything about this Medicare issue or to create an MSA. And that's correct. There's no law that says you have to create a Medicare set-aside arrangement. The government says, essentially, you can choose not to and just pay the bills out of your checkbook. That's perfectly acceptable. But what happens when you get a phone call from a prior client who says, I just got a letter from Medicare and they want $52,000 and I don't have any money left. This settlement, I paid you, I paid back the hospital lien, I paid off my house and all my bills, and then, well, the rest of the money's gone. I don't have money. I don't have money to write a check for $52,000. Can you imagine what your client's going to say next? They're going to say, are you covering this? Didn't you make a mistake? You told me I didn't have to worry about it. So fanning the fears or fanning the flames of fear, no. I'm simply trying to deliver the message that you don't want to ignore these issues. It's going to come back to bite you and your client, and if you ignore it, the problem just builds and builds and builds in your case files. Look, we've got evidence. I was talking to Bruce Cranner, attorney in New Orleans, a defense attorney, but also a Medicare expert. And Bruce told me just this morning that there is evidence now that Medicare CMS is coming after trial lawyer firms, and they're starting with the high volume firms because they know when they audit their files, they're going to find a lot of cases where Medicare conditional payments have been ignored. Medicare is coming after trial lawyers. You may not care about Medicare, but Medicare cares about you. You may think you can ignore Medicare, but Medicare is not going to ignore you. They are going to enforce the law. There's no law about an MSA. There's law since 1980 that says that once Medicare CMS has discovered your client has had a settlement, Medicare is precluded from paying for services that were covered in that settlement. And they're going to have, they've got the records now, here's the letter that proves it, of every charge and when it occurred. They're going to come back and say, we want this money back. We shouldn't have paid it. You should have paid it, plaintiff or beneficiary. So, am I hyping our services? Well, okay, David, in a certain respect, I guess I am, because that's what this whole company is about. We created a company to help trial attorneys help their clients avoid an MSA, if at all possible, and avoid Medicare problems, and to take care of all the liens in these cases. Yeah, I'm hyping my services because I know that we've got the most unusual approach to this of anybody in the country. That's PMLS. That's because we come at it from avoidance. The first words out of our lips when you call us for a consultation is, let's talk about whether your client can qualify to avoid an MSA. And if not, and they decide they want to know how big the potential problem is, we offer a service to identify how big the potential problem is, and the extension of the service is, once we've identified it, then we take proprietary steps to minimize that number to the absolute rock bottom dollar that is reasonable and defensible. Why? Because if the tables were turned and we were the plaintiff in a case facing a settlement that doesn't fully probably make us whole, and now we find out that lien holders want their money and Medicare wants their money, and I may have an obligation to pay future bills that Medicare would have paid except I've had a settlement, this is bad news. I wouldn't want to hear that. I wouldn't want any of my money to go to that. So we created a company to deliver that kind of a result for injury victims and protect the trial attorney. Okay, that's the hype. David, I appreciate your reply. And y'all say this, I don't mind at all being challenged on this. My dad once told me, he said, you know you're over the target when you start taking flack. And I'll consider this some flack, David, and it just means that I'm over the top of the target, and I believe that. I'm right over the top of the target, and it's bombs away. We want to fix this issue for trial attorneys and their clients. We want to help plaintiffs avoid Medicare and MSAs and minimize liens so that they've got more money to take care of their needs and not paying it out to ERISA health plans, Medicare, Medicaid, and putting money unnecessarily in an MSA or overfunding one. So, sorry for the long diatribe, but I thought it was necessary. This has been Jack Meligan for the Plaintiff's MSA and Lien Solution, and I'll be back again next week.